Welcome to the deep dive. We're plunging into, well, the pretty high-stakes world of construction disputes today. It's not just about the building itself. It's these intricate contracts, huge amounts of money flying around.
Absolutely.
And sometimes, even when a legal process is designed for speed, things can go completely off script.
That happens.
So today we're looking at a high court case that really shows how a legal shortcut, meant to be simple, led to a result that must have left one side, well, reeling.
That's right. We're stepping into the technology and construction court, looking at a case between a main contractor and a subbie on a big London data center job.
Oh, wow.
And our mission, our deep dive today, is really to unpack how a smash and grab adjudication, which is supposed to be about quick payment procedural stuff, how it ended up with the adjudicator awarding more money than the claimant even asked for, and then, crucially, how the high court reacted to that. It might make you rethink, what fair play means when your own legal arguments accidentally blow up in your face.
Okay, sounds fascinating. So with stakes that high, let's set the scene. Who were the main players here?
Okay, so on one side, you've got Bell Building Limited. We'll just call them Bell. They were the subcontractor.
Got it.
And on the other side, TClarke Contracting Limited, or TCL. They were the main contractor.
TCL, right, and the project.
Bell was doing the supply and install of the substructure and superstructure for this big data center at Greenwich Point in London.
So the mainframe, floors, roof, that sort of thing.
Exactly, the bones of the building, essentially. And it was a big job. The subcontract sum was just over 20 million quid.
Yeah.
$20,013,088 to be precise.
Serious money.
Definitely. And the contract they were working under was the JCT Design and Build Subcontract Conditions 2016. Pretty standard stuff for the UK.
Okay, so big project, standard contract, cash flow must be critical. And the spark for this whole dispute was, what, an interim payment application?
Yeah.
Number 18.
That's the one. Bell put in interim application number 18. They were asking for a gross sum of $20,915,777.43.
Right.
And the dates were set out clearly in the contract. Due date was May 9th, 2023. Final date for payment was June 19th, 2023.
Okay, so Bell applies for payment. What does TCL do?
Well, this is where the crucial mechanism comes in. If the paying party, TCL here, wants to pay less than what's applied for, they have to issue something called a pay less notice.
And it has to be on time, right, and valid.
Exactly. Spot on. If you don't issue a valid pay less notice by the deadline, you generally have to pay the full amount asked for in that application. That's the core idea behind a smash and grab adjudication. It's about the process, not the true value at that stage.
Oh, right. Procedure over substance, initially, anyway.
Pretty much. So TCL issued their pay less notice 18 on June 6, 2023. They said the notified sum, what they intended to pay, was 710,120 points and 61.
Okay. Much less than the nearly 21 million Pal asked for.
A lot less. And TCL did pay that 710K on June 21st, 2023.
But Bell wasn't happy with that.
Not at all. Bell immediately argued that TCL's pay less notice wasn't valid. For whatever reason, they believed it didn't meet the contractual requirements.
Ah, okay. So they saw their chance for a smash and grab, claiming the full amount from application 18 because the notice stopping it was, in their view, defective.
Precisely. So they launched an adjudication.
And what were they actually asking the adjudicator for? Was it the full difference?
They asked for $1,443,981.51 plus VAT.
Okay, wait. Why 1.4 million, not the full 20-odd million minus the bit they were paid?
That's a key detail we'll come back to. But critically, Bell made it absolutely clear this was only a smash and grab.
How so?
In their notice of adjudication, their referral documents, they explicitly state that they were not asking the adjudicator to decide the true value of the work.
Right.
They reserved the right to argue about the actual value later, if needed. This was purely, your pay less notice was invalid, so pay the sum applied for under application 18.
Got it. Very specific remit. So the adjudicator looks at it. What's the decision?
Decision comes out September 13th, 2023. The adjudicator agrees with Bell. Yes, it's a smash and grab situation. Yes, TCL's pay less notice was invalid.
Okay, so far so good for Bell. They should get their 1.4 million then.
Well, here's the massive twist. The adjudicator ordered TCL to pay Bell £2,129,672.69 plus VAT.
Hold on. 2.1 million. But they only asked for 1.4 million. How on earth did that happen? How can you award more than someone claimed, especially when you were told not to value the work?
It's pretty wild, isn't it? And this is where it gets really interesting and frankly a bit painful for TCL. It all came down to how Bell initially calculated that 1.4 million claim.
Okay, go on.
You see, when Bell worked out their 1.44 million prelation figure, they had actually taken the amount from application 18 and then deducted payments received relating not just to application 18, but also payments received after that under the next application cycle, application number 19.
Ah, I see. So they'd already accounted for some later money they got.
Exactly. Now, TCL, in their defense during the adjudication, challenged this. They argued quite forcefully that the adjudicator couldn't possibly consider payments made under application number 19.
Why not?
Because, TCL argued, this adjudication was only about application note 18 and the validity of Payless Notice 18. Anything related to application 19 was, they said, outside the adjudicator's jurisdiction for this specific dispute.
Okay, that makes sense from TCL's perspective. Limit the scope.
You'd think so. But here's the kicker. The adjudicator agreed with TCL's argument on this point.
He agreed?
Yes. He accepted TCL's submission. He said, okay, you're right. I should exclude consideration of that payment made under application 19. That payment was $679,592.78. So the adjudicator removed that $679K deduction from Bell's calculation for what was due under application 18. And when he did that, corrected arithmetic, as the High Court later called it.
The number went up.
The outstanding sum for application 18 shot up to $2,129,672.69. So TCL's own argument, designed to limit things, directly led to the adjudicator calculating a higher amount due for application 18 than Bell had even claimed initially.
Oh, my word. Talk about an own goal. Hoist by your own petard, indeed.
Absolutely. And on top of that $2.1 million, there was also contractual interest, which is already $37K and ticking up at over £400 a day, plus the adjudicator's own fees of £21,000 plus VAT.
Ouch. So TCL must have been absolutely stunned. Predictably, they challenged this in the High Court.
You bet they did. They weren't going to take that line down. They started what are called Part 8 proceedings, usually for points of law.
Right.
But it got converted to a standard Part 7 claim, which then allowed Bell to apply for summary judgment.
Which is basically saying, there's no real defense here, court. Just enforce the adjudicator's decision now.
Exactly. Quick enforcement. The case ended up before Mr. Jonathan Acton Davis, KC, sitting as a deputy High Court judge. Heard on July 12, 2024, and judgment came out pretty quickly on July 25, 2024.
Okay, so what were TCL's main arguments to the High Court? Why did they think the adjudicator's decision was wrong and shouldn't be enforced?
They had two core arguments. First, lack of jurisdiction. They said the adjudicator exceeded his powers. He wasn't asked to value the work, only rule on the notice, yet by awarding more, he effectively did value it, or at least went beyond the specific smash-and-grab question he was asked.
Makes sense. Argument one. He went too far.
Second, breach of natural justice. This is about fairness. TCL argued that the adjudicator awarding this higher sum came out of the blue. They weren't given a proper chance to address the possibility of him awarding more than claimed based on this calculation point. They felt he'd gone, off on a frolic of his own without giving them fair warning or a right to reply on that specific outcome.
All right, so argument two. It wasn't fair procedurally. Those sound like pretty serious challenges. How did the High Court approach these? What legal principles did they apply?
Yeah, they are standard but serious challenges in adjudication enforcement. The court looked at established case law. On jurisdiction, they referred back to a key case, Cantillon Limited v. Vasco Limited. It essentially says courts and adjudicators shouldn't get bogged down in overly legalistic definitions of the dispute. And crucially, it says the scope of what the adjudicator can decide, the ambit of the reference, can actually be widened by the arguments the defending party makes.
Ah, so your own defense can expand the battlefield, so to speak.
Precisely. If you raise an issue in your defense, you might inadvertently give the adjudicator jurisdiction over it, even if it wasn't in the initial claim.
Interesting. And what about the natural justice point? The frolic of his own argument?
For that, the court again looked at Cantillon and also another important case, Rowe Brickwork Limited v. Waits Construction Limited. These cases establish a few things. First, any breach of natural justice has to be material, significant, not just a minor procedural hiccup.
Right, it has to actually matter.
Yes. And second, an adjudicator is allowed to decide a point based on the material presented, even if neither party argued for that specific outcome, provided, and this is the key bit, provided the parties knew about the relevant evidence or arguments, and the issue was generally fairly canvassed during the process.
So it's only a breach if the adjudicator introduces something totally new that nobody had a chance to comment on.
Exactly. If he genuinely goes off on a frolic, using information or reasoning the parties haven't seen or addressed, but if it arises from the arguments and evidence already in play, even if the specific calculation is novel, it's generally okay.
Okay, so applying those principles, how did the High Court rule on TCL's arguments? Did they find the adjudicator went too far or acted unfairly?
No, they didn't. On the natural justice point, the court found no breach. They pointed out that the information justifying the higher sum, the details about the application 19 payment, was actually put in by Bell in answer to a question from the adjudicator.
Ah, so it wasn't hidden.
Not at all. The judge said both parties were aware of this material. The whole issue of the application 19 payment was canvassed before the adjudicator in correspondence, so everyone knew it was being discussed. The judge was clear. The adjudicator simply corrected the arithmetic based on TCL's own successful argument. He did not perform evaluation. No frolic.
Right, just followed the logic of TCL's own point.
Exactly. And then on jurisdiction, the court found the adjudicator acted within his jurisdiction. Why? Because, as the Cantillon case suggested could happen, TCL's own submissions about excluding the application 19 payment were what opened up the possibility of a different, greater assessment of the sum due for application 18.
So their attempt to narrow the scope actually, legally, widened it in this specific way.
That's precisely how the court saw it. They triggered the recalculation themselves.
So the bottom line, Bell wins in the High Court.
Bell wins. The court granted summary judgment. It basically means TCL had no realistically arguable defense against enforcing the adjudicator's decision for the full $2.1 million plus interest and costs.
Wow. So the adjudicator's higher award stands? TCL has to pay up.
Correct. It's a stark reminder of how robust adjudication enforcement is. It's really, really hard to overturn these decisions in court, especially on jurisdiction or natural justice grounds. The courts bend over backwards to support the process. And this case shows, quite dramatically, how your own arguments as the responding party can sometimes backfire and expand the scope against you.
It really underlines that even in these supposedly straightforward smash-and-grab cases, every single detail matters. How you frame your claim, sure, but also, crucially, how you frame your defense and respond to points raised during the adjudication can have a massive, unexpected financial implications.
Absolutely. Be careful what you argue for. You might just get it. And then some.
A powerful lesson. So thinking about this, it really leaves us with a question, doesn't it? How might this case influence how parties approach adjudications going forward? Will people be more cautious about the arguments they raise in defense, knowing they could inadvertently open the door to a higher award than the claimant even asked for? What do you think?